Before we start, I think Justice Jennings has something to say about what you can expect this afternoon in terms of some of the cross-examinations.
Yeah. I just want to make a comment on what's coming up. You're about to see the cross-examination of Wayne Rudson on his report, which is in your material tab 4, and you should have it open when the cross goes on. But I want you to watch the first cross-examination, that is of Wayne Rudson, done by Phil Epstein, carefully, and keep it in your mind when you get down to the cross-examination done by George Hunter of Douglas Hyatt, because they are both effective cross-examinations and diametrically opposed in style. And it'll be up to you to determine which style you think, under the circumstances, was the most effective. But it's a fascinating contrast, and I commend the comparison to you.
Thank you. Okay, so we will now do the Phil and Wayne show.
Mr. Epstein, do you wish to cross-examine?
Yes, thank you, Your Honor. Just before I begin, Your Honor, I want to straighten out one matter between my friend and I that I think my friend innocently misstated himself. The report you have of Mr. Rudson, of which I've been provided a copy, is for the purpose of you to follow the evidence, both in chief and cross-examination, but it's not an exhibit. The witness is here live, and I object to the report going in as an exhibit.
Very well. I wish rather that had been brought up somewhat earlier, but I'll hear argument on the matter later. Normally, without a jury, I'll allow the report to be filed as an aid to me to the witness's evidence, but you move along and we'll see how we do.
Thank you. Mr. Rudson, you've given extensive evidence in chief about this report. Would you put it in front of you, please?
Yes, I have it.
And on page 1, you indicate that this report constitutes an opinion. Is that correct?
Yes.
And in the kind of work you do, opinion is the highest level of assurance that you give to the client or the court, as opposed to an estimate or a calculation.
That's right.
And an opinion requires more work than a simple calculation.
Yes.
It requires you to do some verification and some investigation of the facts.
Yes.
And you've known for some time, Mr. Rudson, that you are going to be examined by me today.
Yes.
And you and I have crossed swords before.
Yes, we have.
You expected me to be reasonably thorough.
Yes.
You brought your complete file with you, I expect, therefore?
I have some of my material with me and some is still in my office.
Really? You expected me to be thorough, but you left half your file in your office? Is that what you did?
No, I didn't leave half of it in my office, Mr. Epstein.
Do you have the retainer letter, Mr. Rudson?
No.
You don't? You left that in your office?
The correspondence file is in my office.
The retainer letter is in your office?
That's right.
The letter by which you were instructed to do the investigation and opinion is in your office?
Correct.
Notwithstanding, you expected me to be thorough.
I didn't consider your thoroughness in my decision as to what to bring today.
I see. Mr. Rudson, you had meetings with Mr. and Mrs. Doe in accordance with your assignment in order to investigate the matter?
Yes, I did.
And did you make detailed summaries of key meetings and discussions with Mr. and Mrs. Doe?
Yes, I did.
And of course, let me guess, Mr. Rudson, they're in your office as well.
Some of them are here. I can look to see which specific meeting you'd like me to refer to, and
Well,
I can
do you have
answer your
any
question.
specific notes of any specific meeting with Mr. Doe present with you today?
Well, some of them, in fact, are repeated in my report.
So when we come to the section in the report where you talk of meetings with Mr. Doe, you'll have those summaries with you?
Well, we can deal with those when we come to them, and then I can answer your question.
Well, perhaps at the break, Mr. Rudson, you would go through your file and give me a copy of the notes that you have of your meetings with Mr. Doe and Mrs. Doe?
I can certainly make those available to you.
Thank you. Well, we'll do that at the break, and we won't take the court's time now.
Mr. Rudson, is this the first time this request has been made by Mr. Epstein?
Yes, it is, Your Honor.
Thank you very much.
Let's turn to the bottom of page 1 of the report, Mr. Rudson. You refer to the findings subject to the assumptions, qualifications, and restrictions. So I take it you accept the fact that if the facts that you have assumed are incorrect, then the conclusions of the report are also incorrect?
Yes.
And if the assumptions that you have made are incorrect, then the findings are also incorrect.
Yes.
The opinion that you have given requires you to bring some judgment to this process,
Yes.
and some of that judgment is subjective, correct?
To the extent that it's my own judgment and it may differ from that of another individual or this honorable court, you could say it's subjective.
It's subjective, Mr. Rudson, is it not?
I don't know what you mean by subjective. If subjective means whim or preference or attitude, I would say it's not subjective. If you refer to an interpretation of facts based on experience and analysis and the application of judgment, to that extent, there was some subjectivity in this report, as in all reports like this.
And as part of that subjectivity, Mr. Rudson, which you have well defined, you had to form a view as to whether you accepted the evidence of Mrs. Doe or Mr. Doe, correct?
In certain cases, there was conflict between the two parties, and it required my judgment to determine which description of events was more reasonable for the purpose of my report.
Did you hear my question?
Yes.
What was my question, Mr. Rudson?
You asked about the exercise of subjectivity in my report.
No, I asked you if you had to decide whether Mr. or Mrs. Doe's version of the events was true or not, which one you accepted. You had to do that, didn't you?
I wouldn't want to put it that simply, as I relied only on one or the other's version of any particular event, Mr. Epstein. It was a deeper and more in-depth analysis than that.
All right. Well, when we come to those areas, we'll take a look and see how deeply that was done, Mr. Rudson. The report speaks to the end of the calendar year 1998. Is that correct?
In a few instances, yes.
Well, you looked at previous year's income as well, but my point is you didn't go beyond December 31st, 1998, correct?
Correct.
And you cannot help us as to how Mr. Doe has been doing in his professional activities and his income from January 1st, 1999 to date, correct?
Correct.
All right. I want you to turn, please, if you could, Mr. Rudson, and for your Honor's help, I'm looking at page, well, it's Exhibit A, page 1 of 2 and Exhibit A, which follows the page 7. In looking at Mr. Doe's professional income, Mr. Rudson, we see that in 1996 he earned $99,107.
Yes.
And in 1998, from his income tax return, you've extrapolated the number of $195,241, correct?
Correct.
And you took that number from his income tax return, correct?
Correct.
And you're familiar with the child support guidelines, Mr. Rudson?
Yes, I am.
And in particular, you're familiar with Section 17 of the guidelines? I noticed you carry them with you. That's one of the things you did remember to bring with you.
I have the guidelines with me.
Yes. And Section 17 you're familiar with?
Yes, in fact, it's paraphrased in my report.
Yes. And, 17C I direct your attention to. Is that paraphrased in your report?
Yes, it is.
Where the spouse has received a non-recurring amount in any of the 3 most taxation years to be such portion of the amount as the court considers appropriate, if any. You see that section?
Yes, I do.
Did you ask Mr. Doe if in the $195,241 that he declared in 1998, whether there was any non-recurring amount in that taxation year? That's a simple yes or no, Mr. Rudson.
I'm trying to recall. I don't believe the question was asked in that way, no.
So I take it from that answer, Mr. Rudson, you are not aware of whether there has been any non-recurring amount in the past 3 taxation years for Mr. Doe. Isn't that correct?
None were brought to my attention during my investigation.
And you're not aware of any?
That's right.
If that's so, excuse me, Mr. Epstein, if that's so, what's the purpose of note 1C on page 2 of your exhibit?
Simply, Your Honor, to properly paraphrase the entire section 17.1 of the Child Support Guidelines.
I see. You're not saying you did that. You're just putting it in there.
And in part to recognize that that was part of my investigation. In the event that I found any non-recurring items, they would have been adjusted for. But I did not.
I'm not sure I understand that, but all right, go ahead, Mr. Epstein.
Well, you've anticipated me, Your Honor, because that's where I was going next, which is Exhibit A, page 2 of 2. That's where you paraphrase 17C.
Yes.
You agree that 17C is an important factor in determining income.
Yes.
And you are well aware from having looked at Mr. Doe's last 3 taxation years that his income in 1998 doubled from 1996, correct?
With respect to his professional income,
Yes.
that's approximately right.
Yes, and Mr. Doe is a sole practitioner accountant.
Accountant and mortgage broker.
Yes, correct?
Yes.
And his income doubled.
His net income approximately doubled, yes, in over those 3 years.
And yet you did not ask Mr. Doe why his income had doubled. Isn't that correct?
No, that's not correct. We discussed...
You did ask him that specifically?
Well, I'm not sure I used the exact words that you're referring to, but I can tell you that as part of my investigation, I spoke to Mr. Doe directly about his 1998 income and whether there was any adjustments that he felt ought to be made to that income as representative of what his expected future income would be, and he did not indicate any.
Well, Mr. Rudson, Mr. Doe indicated, well, we weren't in 1999 when the time you did your report, correct?
Early 1999.
Right. And you know that from the pleadings, Mr. Doe takes the position that his anticipated income for 1999 is $100,000. You know that now?
I've read the pleadings.
Right. So he seems to be suggesting, at least from his material, that his income is back to 1996 levels.
He may through the pleadings, but it's certainly not what he told me in my investigation.
And my simple point, Mr. Rudson, is you did not determine from speaking to Mr. Doe whether there was or there was not a non-recurring item.
We discussed the value of 1998 as a predictor of future income, and Mr. Doe did not bring to my attention any items that he felt would not recur in the future.
Are you familiar with the Whiteside mortgage transaction?
No.
When Mr. Doe testifies, Mr. Rudson, he will talk about a $60,000 fee he got, 6 times any fee that he had ever received before in any mortgage transaction. Were you aware of that?
No, and I'm not sure what year you're referring to.
I'm
either.
referring to 1998, in which he received a fee of $60,000 on 1 mortgage transaction. You're not aware of it?
No.
And you did not have a discussion with Mr. Doe about it?
No, I did not.
And if you had been aware of it and had been told that he had received a dramatically unusual fee in that year, you would consider, would you not, Mr. Rudson, that that well could be a non-recurring item if he received a very unusual fee?
I would certainly want to investigate that, yes.
And if you found it was a very unusual one-time fee, that would be a non-recurring item, as you've indicated in Section 17C.
Possibly.
Yes. And if so, should be taken into account.
Yes.
Yes. All right. Let's carry on. I note that in some cases, when you make an adjustment on Exhibit A, page 1 of 2, that you use an average. So, for example, when you use the interest figure, you have of 893, 722, and 978, you have averaged the amount.
Correct.
But in using the professional income figure, you did not average the amount.
Correct. Where there was a trend, I respected the trend.
Where the numbers were going up, you didn't average, but where the numbers were all over the place, you averaged. Correct?
Well, that may be the result, but it's consistent with my reading of 17.1 of the guidelines that state that where the income, the amount of income has increased in each of the 3 most recent years or has decreased in each of those years, we have used the amount from the most recent year,
Yes,
which I believe is consistent with the guidelines.
Mr. Rudson, I'm just asking what you did on Exhibit A. I'm just trying to understand Exhibit A, page 1 of 2. Right? That wasn't the question I asked you. In fairness, just listen to the question and we'll get along more quickly.
Well, I think to be fair, he told me that he followed the guidelines, which is why he didn't average. In any event, move on. I think I can
Fair
read the figures.
Fair enough. Let's go to the adjustments to reported income, Mr. Rudson. What you have essentially done is added back in or imputed to Mr. Doe $7,000 for alleged barter transactions in which Mr. Doe was involved, correct?
That's one of the adjustments, yes.
Yes. And that section is covered in page 4 of your report,
Yes?
which begins with the words, "We understand."
Correct.
And when you say "we," does that firstly mean you?
It's my firm's report.
Did someone else work on this report, Mr. Rudson?
Yes.
And who was that?
His name is Martin Pont.
And Mr. Pont spent how many hours on this matter?
I don't know offhand.
Well, can you give me your best estimate?
Maybe 30 to 40 hours.
Right. And how many hours did you spend, Mr. Rudson?
I don't know.
What's your best estimate?
15?
So, in fairness, Mr. Pont did the bulk of the report.
I wouldn't characterize it that way.
Well, he did spend twice as much time on it as you did.
Yes, that's true.
And when you say "we understand," essentially on this section, what you mean is that is what you have been told by Mrs. Doe, correct?
In this particular section,
Yes.
You are right.
Right. So you would agree with me in terms of understanding the barter imputation, it didn't require any expert opinion. That is, you've simply put in to your report what Mrs. Doe told you.
No, that's not true.
Well, we'll come to that in a minute. We'll see what exactly you did do. Ms. Doe told you that her husband bartered on a yearly basis for certain matters, correct?
Yes.
And you specifically put that to Mr. Doe, correct?
Correct.
And he unequivocally denied it.
Yes, he did.
And you accepted Mrs. Doe's version over Mr. Doe.
Correct.
And you accept, I assume, Mr. Rudson, that Mrs. Doe would have a motive to mislead you in connection with this matter?
Perhaps.
Mr. Rudson, would Ms. Doe have a motive to mislead you in this matter?
Mr. Epstein, I did not consider that when I did my report.
I know, Mr. Rudson, that's my complaint. But my first question is, did you accept that Mrs. Doe would have a motive to mislead you?
I'll accept that.
Yes. It's not a perhaps. The more that her husband makes, the more she will get. That's axiomatic, is it not?
Well, this is a child support case, but,
And well, doesn't that also apply, Mr. Rudson?
well, you said she. I think the
Well, she's the
calculation
one
is
getting
for
the child
purposes
support, right?
of child support.
Mr. Rudson?
Mr. Epstein, it did not matter to me their motivation. My job as an independent expert is to satisfy myself that my opinion can assist the court in this matter.
There's no expertise on this particular section in the report. You just conceded that a few minutes ago.
No, I did not concede that, and I disagree with you.
All right, Mr. Rudson, I put to you that with respect to Section 4.2, essentially what you have done is accept Ms. Doe's word over Mr. Doe's that there have been barter transactions.
There was more to the analysis than simply accepting Ms. Doe's assertion about
All right.
this. There was further investigation and analysis,
All right.
so that on balance, based on my experience, it's my opinion that this is a legitimate component of his income.
If it's true.
I presume that it's true based on my analysis, and I'm giving my opinion that it is true.
Who owns
Maybe you
the-
could help me with this, for example. She told you he got ski equipment worth $1,000. He said no. I think what Mr. Epstein wants to know is where to go from there. Did you go and look at the skis, or did you?
I'm going to take you through it, Your Honor. So if you asked that question on my behalf, Your Honor, I withdraw.
I've asked it on my behalf because you two are having a bit of an argument here, and I want to see what he did.
Well, I'm going to take him through it in detail, Your Honor. So if I might,
I invite you to start.
I will. Mr. Rudson, did you ascertain the owner of the Florida condo?
No.
When Mr. Doe testifies, he will tell us that it's George Rawlinson. You did not know that?
I had heard the name Rawlinson, but I didn't do a title search. I'm not sure who's the titled owner of that.
And were you aware that Mr. Doe and Mr. Rawlinson have been close friends for 30 years?
Yes, I am aware of that.
And did you interview Mr. Rawlinson?
No.
Did, when Mr. Doe met with you, he specifically denied that he had done any services for Mr. Rawlinson. Isn't that correct?
He didn't answer the question that way.
Right. Well, what services do you say he performed, Mr. Rawlinson? Was it accounting services or brokerage services? Which one?
I'm not sure.
You're not sure which services?
Right.
Right. And I presume that you would expect, Mr. Rudson, that if Mr. Doe performed accounting services for Mr. Rawlinson, whether or not there was an invoice, there would at least be a file in Mr. Doe's office with the name Rawlinson on it.
Not necessarily.
Not necessarily. Did you look and see whether there was a Rawlinson file?
No.
Well, of course you couldn't have, because you didn't know the name.
I did not look at any file named Rawlinson.
You didn't know the name of the condo owner, correct?
Correct.
You didn't know the relationship between Mr. Doe and the condo owner?
No, that is incorrect. I knew that there were services, or it was discussed that there were services
I was asking about the
rendered
relationship.
by Mr. Doe for the owner of the condo.
And the owner of the condo, we know, is Mr. Rawlinson, who was a friend of Mr. Doe's. And Mrs. Doe told you that her husband said he had done services for Mr. Rawlinson, and Mr. Doe told you that he had not done services for Mr. Rawlinson.
That's not what Mr. Doe said.
Has what Mr. Doe said found its way into this report anywhere?
Yes?
Where?
Mr. Doe denied the existence of these barter transactions, and that's the way I answered your question.
Right.
He did not deny whether he rendered any services for Mr. Rawlinson. I didn't ask him that question.
You didn't ask him whether he rendered any services?
For Mr. Rawlinson specifically, that's right.
So notwithstanding you allege that he bartered a Florida condominium on an annual basis to which you impute $5,000 per year, you did not inquire of Mr. Doe whether he had done services for the owner, Mr. Rawlinson. Isn't that fair?
I inquired about barter.
Mr. Rudson, please, just answer the question. Did you inquire in connection with this $5,000 condominium as to whether Mr. Doe had done services for Mr. Rawlinson?
I did not ask about Mr. Rawlinson.
Well, did you ask about the owner, in quotation marks?
I asked about these transactions, Mr.
And
Epstein.
Mr. Doe unequivocally denied it.
He denied there was any barter transactions.
Fair enough. And if I take you through some of the others, for example, you say that Mr. Doe received in exchange of services golf clubs. Do you know who gave Mr. Doe the golf clubs?
The golf clubs were received in 1996.
Yes. And do you know who gave him the golf clubs?
No.
Did you ask Mr. Doe who gave him the golf clubs?
He denied there was any barter transactions. I did not ask him about who gave him the golf clubs or any of these other items.
Did you ask him who gave him the ski equipment?
No.
Did you ask him who gave him the biking equipment?
No.
Did you ask him how he got the fitness memberships?
No.
Let's go to another area, Smith Steel. Smith Steel. You suggest in your report that Mr. Doe should be imputed with further income in that he could essentially withdraw monies from Smith Steel, correct?
Not precisely, no.
That's a generalization. Under the guidelines, undistributed money out of a company may be imputed to a shareholder, correct?
Correct.
And that's what you're suggesting should be done in this case?
Correct.
All right. And that implies, does it not, Mr. Rudson, that Mr. Doe would be free to withdraw $200,000 from Smith Steel Limited?
Well, no, that's not quite right. He's a 50% shareholder, so he's not free to withdraw all of the income of the company. The answer to your question is that the income of the company is available to him and the other shareholder if they choose to withdraw it.
Yes. You've imputed $99,000, let's round it off, $100,000 to Mr. Doe out of Smith Steel, correct?
Correct.
All right. And you have added that to his total imputed income and suggested that it's the total income that he earns from his practice and the imputed income that should be used to calculate the child support under the guidelines, correct?
Yes?
So you are assuming, therefore, if you're imputing it into Mr. Doe's hands, that he can get at it, correct? That he can withdraw it from the company. Otherwise, it's stuck in the company and he can't use it.
I'm not necessarily making the assumption that you're suggesting. I'm respecting the guidelines. I've analyzed the balance sheet of the company. I've seen the excess cash resources that it has and the ability for such a distribution
Mr. Rudson.
in order to come to the conclusion that it's available if he chooses with the cooperation of his brother, the other shareholder.
Yes, but in order to pay child support based on 400 plus income, he would have to get the $99,000 out of the company, correct?
Not necessarily.
All right, well, let's analyze this some more. First of all, you agree with me, Mr. Rudson, that Mr. Doe does not have control of Smith Steel Limited. He's a 50% shareholder,
He is a 50% shareholder.
and in order for the company to make distributions, the board of directors has to vote on distributions.
Yes,
And Mr. Doe cannot unilaterally vote on a distribution.
that's right.
He will require his brother's consent.
They would have to work together, yes.
Did you interview Harold Robertson, the chief financial officer of this company?
No, I was denied access to the records of the company.
Mr. Rudson, that wasn't the question I asked you, was it?
Well, it's in my
That was
report,
a
Mr.
gratuitous response by you?
Mr.
I simply asked you, Mr. Rudson, did you interview Harold Robertson, the chief financial officer of the company? That's a very simple question. Did you?
No.
You understand, Mr. Rudson, that your role is here as an expert?
Yes.
And you understand that your role here is to be neutral
Yes.
and to just cover the matters upon which you were engaged?
Yes.
All right, so why would you gratuitously, when I asked you if you interviewed Mr. Robertson, respond you were denied access to the records of the company?
I think it's important for the court to know that that is a procedure that I would have liked to undertake had I been able to, but I was not allowed to do that investigation, Mr. Epstein.
And did you report back to Mr. Safran that you were unable to get access to the records?
Yes, I did.
And did you tell him it would be more useful if you could?
Yes, in fact, that limitation is outlined in my report.
Yes, and did you discuss with Mr. Safran him getting a court order to allow you to inspect the records?
We didn't discuss what legal strategies he had available to him.
Mr. Rudson, you've probably done hundreds of reports.
Yes.
In the course of doing those reports, sometimes you're denied initially access to information,
Sometimes.
and when you pursue it, you get it, either by consent or court order?
Sometimes.
Yes. And when you're entitled to get it, you get it. Isn't that your usual experience?
We don't always get everything we would like.
Mr. Rudson, not only does Mr. Doe have no control, but your suggestion is that, I take it, that he and his brother could have drawn out for the past 3 years $200,000 per year?
That was the pre-tax income of the company.
Yes, but you're imputing $99,000 to Mr. Doe, so we have to impute the same $99,000 to his brother, correct?
That's the figure I've used, yes.
Yes, so that would be $200,000 per year, correct?
Approximately. It was a little less in 1997.
Right. And if we take that back 3 years, that's $600,000, correct?
That was the total pre-tax earnings of the company over those 3 years.
If you're imputing $100,000 per year and you're taking it back over 3 years, that's $600,000, correct?
For the two of them, yes.
Yes. And the retained earnings of the company, you'll find that, Your Honor, on page... It's a pity you didn't number these pages, Mr. Rudson, for ease of following, but you'll find it on Exhibit C, Your Honor, which is the third last page.
Yes, thank you.
The retained earnings of the company are now $426,852. That's at the bottom right-hand side of the report.
Yes.
And of course, if you'd taken if the company directors had taken $600,000 out over the last 3 years, the company would be in a deficit position, correct?
Yes.
Yes. Historically, income has not been distributed from this company, correct?
Correct. At least not in the 3 years that I looked at.
Right. And it's usual in your experience that companies require working capital?
Yes.
And the amount of working capital would depend sometimes on the company's plans for mergers and acquisitions or future needs for cash.
Could you repeat the question, please?
A company's need for cash might depend on the company's future plans for mergers or acquisitions. That is, if Smith Steel was planning on acquiring another company, it might need the cash to acquire another company?
Perhaps?
Yes. You were not able to discuss this with Mr. Robertson?
Correct.
You did not discuss this with Mr. Doe, correct?
Correct.
You simply assumed that the earnings out of the company were available for distribution given the performance of the company, correct?
No, I imputed the pre-tax income of the company into Mr. Doe's income, consistent with the guidelines.
Without regard to whether it might be needed.
No, that's not true either. As I mentioned earlier, I examined the balance sheet, and you'll see that the company has approximately $350,000 of liquid funds.
I thought we just agreed, Mr. Rudson, that the company's need for cash might depend on its plans for mergers or acquisitions?
That's speculative. I have no knowledge of that.
Well, it's only speculative because you didn't ask about it, Mr. Rudson. Isn't that the case?
It's speculative, period. I don't have any information about the future requirements of this excess funds of $350,000.
And I put to you specifically that you didn't ask Mr. Doe or Mr. Robertson about it.
Because I was denied access.
Is this company an operating company? So it's a manufacturing concern, is it?
It's actually a trading company, Your Honor. It buys and sells over the telephone.
What I'm getting at is I don't see any bank debt, and I assume it uses its retained earnings to finance its daily operations.
Well, in fact, that's correct, and it has substantial working capital of approximately $400,000 available to it. It doesn't maintain inventory. It has nominal capital assets.
I guess my problem is I didn't see anything in your report which would help me with what a reasonable amount of working capital would be to meet the company's ongoing requirements. I think that's where you and Mr. Epstein are having trouble.
For example, in that regard, Your Honor, 1 month's payroll alone would be $167,000, would it not?
Approximately.
Yes, so if they had a bad month, they'd need $167,000 to cover their payroll if the income wasn't coming in.
Yes.
And 2 months would, 2 bad months in a row would eat up all the retained earnings, virtually.
It's conceivable.
Yes. So it's important that a company have working capital in order to make sure that it doesn't go into a deficit position.
Generally speaking, yes.
Right. And 167 a month is, given the size of this company, a reasonably hefty payroll.
I agree.
And given the amount of retained earnings, a very significant payroll.
I don't know that.
You don't know that. Let's turn, Mr. Rudson, just before the break, to the investment income. You've imputed income of $58,000 to Mr. Doe from his investment portfolio.
That's right.
You'll find that, Your Honor, on page 6, item 4.6.
Yes, thank you.
Now, Mr. Doe has a stock portfolio, and you indicate from your report at the bottom of page Exhibit A, page 2 of 2, Your Honor, that after Mr. Doe pays his wife the equalization payment, he'll have about $1.1 million left to invest.
That's right.
And currently, this is in stocks traded on the market.
That's right.
And what you have done is assume that he could take all of those stocks, sell them, turn all the money into cash, and buy a treasury bill, correct?
Correct.
And you are not, I take it, Mr. Rudson, a certified financial planner,
No, I'm not.
but
Epstein, I don't think you need to spend a lot of time on this point.
it was my best point, Your Honor. But
Well, if you wish to spend the time on it, but read my lips.
I read them very well and clear, Your Honor. Perhaps this would be a good time to take a break and let Mr. Rudson go back to his office, get those notes that I need, and then we'll continue.
Thank you, Mr. Epstein. I'll suggest that perhaps you might do that.
Thank you, Your Honor.
Can Mr. Epstein and Mr. Rudson come up here, please? I promised Phil I would not make any jokes about the fact that he no longer has any hair on his face, but you can recognize him. So let's start with you, Phil. What did you do to prepare for this examination?
I went to a bar. I first looked at this report, and in terms of preparation, I read it about 5 times, and I picked out what I thought were the key words and key facts And then I immediately faxed a copy of the report to Michael Penner, and a second copy of the report to Linda Brent, who are experienced chartered business valuators, and immediately made a telephone appointment with them to review in detail Mr. Rudson's report, and spent an hour with each of them going over the very significant frailties in this report of Mr. Rudson. My only regret is that I wasn't able to demonstrate them on cross-examination, but I was extensively briefed, as I would always be when tackling an expert of any kind. I would never ever tackle an expert on cross-examination without being briefed by a similar and at least equal expert to review what was being told. So I had extensive preparation for this cross-examination, and most of the areas in which I attempted to cross-examine, I was directed to by the two business valuators.
All right. Looking at the video today, Phil, was there anything that sort of jumped out at you that you regretted having asked, or an area that you?
Yeah, I regret the entire video. That's a very aggressive cross-examination, and although those of you that know me think that's exactly how I would cross-examine in every circumstance, that's not how I would cross-examine. I don't think. Mr. Rudson did get me upset at a couple of times where he tried to fix, while he was in the stand, some parts of this report and deflect me from areas I thought were brilliantly conceived as in terms of cross-examination. But it's a little too aggressive for my liking. Whenever you do this kind of program and you're doing a mock video, you never have the time to set the witness up properly. And so you have a tendency on a video performance to go for a quick kill. Whenever you go for a quick kill in a cross-examination, it's usually the cross-examiner who ends up killed. So this is not patient enough, and there's not sufficient setup. The Smith-Steele one, I think, works pretty well. You can't take this money out of the company that Mr. Rudson suggests, or as easily as he suggests, but it's a little too hurried. I think Justice Jennings caught it, but Justice Jennings had 30 years experience at the family law bar, and if I were doing that generally with another judge, I would have done that much slower in terms of demonstrating why you can't get at this money. So generally, it's too compressed, and it's a little bit aggressive.
Right, but one of the things that I noticed was when you cross-examined Wayne about something that was fairly self-evident, which was that he had averaged the interest income, but had just simply used the last year of the professional income. By asking the question, you permitted him to give an answer which he otherwise wouldn't have to give, and you could have just saved it for submissions. Is that kind of stuff that you look back on and say, I wish I hadn't asked that question?
There are many questions in this I probably would rather not have asked. I tried not to ask any questions of an expert to which I do not already know the answer. I know that is often trite, and sometimes I will gamble, but I don't usually gamble with an expert. And I asked that question for a specific reason. I know because of the page right beside it where he summarizes 17 A, B, and C that he isn't supposed to average for the purposes of picking the guideline income figure. I wasn't directing his mind to the guidelines. I was just directing his mind to what he had done at that point in time. If I saved it for argument, Harold, I think I would have got in trouble with the trial judge, because the trial judge would have said that's exactly what he's supposed to do. He's supposed to take the last year's income. So I just wanted at that point in time, I needed to get Mr. Rudson is a very experienced witness. And one of the problems with tackling as an experienced witness is they're too comfortable in the witness box. So I needed to upset Mr. Rudson a bit. And one of the early goals in this was to get him a little bit upset and try to get him a little bit uncomfortable. And that's very hard to do with an experienced witness.
Is that right, Wayne? Did you get upset early on?
Well, it started at lunch before the session even started.
Yes. What did he say to you over lunch?
Phil
I
said,
don't think you can say that, Wayne, what I said to you after lunch, but you could paraphrase it.
I'll paraphrase it because he looked over at me and said, you know, I'm surprised you agreed to do this because it's basically a no-win situation for you. Your best day is you'll get injured. Your worst day is I'm going to kill you. That's how it started.
Wayne, we've heard what Phil did to prepare. What would you, not just for this program, but what would you generally do to prepare for a cross-examination by somebody as experienced as Phil?
I think the best preparation an expert witness can do is to be prepared. And I tell people who are going to testify that they should read their report, and read it again, and read it a third time, and just don't be comfortable with your knowledge of the case and knowledge of the facts. You have to be so confident that you know every last detail, that you're prepared to admit if there is an error, or if there is a judgment, or if there is a hole. But be confident enough to know when you can defend yourself and stand up for your findings. Any points you think that Mr. Epstein made, I can tell you were deliberately planted on my part. That would never occur in real life, but really, in a case like this, it was all hypothetical, but in real cases, there are so many areas of judgment, and that's the first thing that Phil went after. He started it that way. He made me admit that there is some subjectivity, and in all expert reports that you're ever going to see, I think that is, in my experience, the most successful areas to be cross-examined on. There's no way a lawyer is going to be able to challenge me on some calculation or some accounting term or valuation issue. But if they can find out the weaknesses in the report, the areas where I had to exercise some judgment, make assumptions and subjectivity, and Phil started by saying, isn't that true? Isn't that what you had to do? And I admitted it. And he went through the report, talked about that I relied on one spouse and not the other, and tried to attack all the areas where I had to exercise judgment. And that, as an expert, is the most difficult part of a cross-examination. And he was very well prepared with the help of the other business valuators. And I can say to you that that was a very realistic process. That was maybe more intense, more challenging to me than any real-life case I've ever given evidence before. I didn't even like watching it just now. But
it seemed that you and Phil had a fundamental disagreement on the undistributed income issue, and that you were coming at it from different points of view. Justice Jennings?
No, I don't think it was a disagreement. I'll come to that.
Right.
Sorry, you were asking me a question?
No, well, actually, that seemed to be an issue that separated the two of them and would have accounted for probably, it was $100,000 of income, but I took it that Phil's evidence was that in order to impute that, or Phil's examination was that in order to impute that money into income of the husband, it would have to be available to the husband. And I think that Wayne didn't take the extra step of saying that it had to be actually paid out to the husband.
No, I didn't take it that way at all. I thought what he was trying to show me, and in fact, he got me on his side because I asked a much better question. That was that it had to be available by virtue of a reasonable business decision to pay the money out. I mean, the money's available, it's there. He could have got it if he hit his brother-in-law over the head or his brother over the head. But that's not the question. The question is it reasonable for that company to pay that money out? And that's where I thought Phil did a very good job.
Yeah, I think that's the. I spent too much time on the barter, given the small amount of the gain there. But on the $100,000 out of Smith's deal, it probably the bulk of it isn't really available. And Mr. Rudson, I was able to get Mr. Rudson to admit, by of course creating in the middle of a cross-examination a wholly fictional chief executive officer, that he didn't know enough to know whether this income was actually available to the husband. Clearly, just because the income is there, you can't impute it. It's got to be reasonably available, and that's the one area where he gave me some room. And of course, if you do back up the $600,000, Linda Brent, of course, pointed out that if you take $200,000 out a year and 3 years, that's $600,000, leaves the company in deficit. I wouldn't have been able to figure that out on my own. I needed help to figure that out, but once I figured it out, I know how to cross-examine on it.
Well, the reason I wanted you to take a close look at that cross-examination wasn't, I confess, as readily apparent to me as it was in real life. In real life, when we taped it, we were sitting very close together. And I could feel a wave of hostility coming from Phil that certainly was washing over the witness and splattering a bit on me. And that is my definition of a cross-examination. It didn't show up as much on the screen. It was an extraordinarily effective cross-examination, but I warn you, be careful. First of all, you're cross-examining Mr. Clean. I mean, he looks terrific. And if you pick on him, I mean, he looks like he's 12 and will. Phil is being really mean with the old "you left your file back at the office" trick. Now, that may work sometimes, but if you've been in the division for a few times, it doesn't work too much anymore. It doesn't impress the judge. The risk is, if you don't do it properly, the judge will become sympathetic to the witness. What it does do, or can do, and I think began to do here, was irritate the witness sufficiently that he starts making statements that are probably a little too defensive and go a little too far. But it's risky. When you see there's another approach coming up, and you've got to decide which one you can handle. Now, I'm not going to tell you either one is right. I just want you to understand that it has to blend with your own personality. Phil is absolutely dead right. You would never, at least you'd be mad if you ever tried, cross-examining someone of Wayne's ilk without following a script laid out for you by your own appraiser. I mean, you'd just be mad to do it. And what you are really doing is you get your appraiser's report, your own expert's report in, and with that expert you pick the 3 or 4 chinks in the armor that you think you can find, and you go for them. And that's, again, precisely what Phil did. You'll see in medical malpractice actions a lot. If you ever get a chance to sit down and watch one, I recommend you do it, because that's where experts disagree dramatically and are called on both sides all the time. And it's worthwhile seeing how expert witnesses in that scenario are cross-examined. And Wayne started to tell you about it. You can always get a reasonable expert to agree that there's an air of subjectivity about his opinion. You can always get a reasonable expert witness to agree that other reasonable experts will hold a contrary opinion, and that contrary opinion can be professed by someone who's equally well qualified as the person, as he is, the person giving the evidence now. And you can work your way into little areas like that, which are a terrific way to start off a cross-examination, which is sort of what Phil did after he got over the "where's the file" business. He exercised superb control of the witness. A couple of times when Wayne got defensive and began to wander, Phil brought him back very, very effectively. I thought at first his chasing of the barter issue took more time than it ought to for effectively, I don't know, 7 or 8 grand, I think was what it worked out to on the rental offset. But having rethought it, it was kind of a dumb thing to throw into the report, and Wayne was sandbagged to that extent because there really wasn't any checking. What he had done is he'd become a judge. He'd said, okay, I accept this evidence and not that evidence. That's my job. So I thought, gee, if he's maybe been a little fast there, how do I look at the rest of it? And that then led into the Smith-Steele thing, which was, I thought, very well handled, perfectly handled, because the whole question is not that the money's there, but is it reasonable to expect that it should all be taken out? And then by that time, when you get to the take your money out of the stock market and put it in whoop-de-doo investment certificates, you're pushing on an open door. It doesn't make any sense.
Any response, Phil?
Well, it's hard to disagree with that. My experience with Justice Jennings, when I have tried the cases in front of him, and I think that's only once, actually. I've only done 2 trials in my life, so one of them was in front of him. And Justice Jennings has a tendency to see where you're going, and he was a very good advocate, and he misses the advocacy, so just when you set the trap, he springs the question. He did it twice in this cross-examination. I was working the witness up to where I finally had a good point, and he gets it. So I thought that was kind of amusing when I was watching it. I agree with Justice Jennings. I don't. This may be useful from time to time to look at how other people do cross-examinations, but cross-examination, although you can teach people to cross-examine, I think you can teach a lot about cross-examination, certainly how to control witnesses and how to ask short questions and so on. Ultimately, your style must be your own. It's a bit embarrassing actually to say that, because then I have to look at what that video looks like in terms of my style, but overly aggressive cross-examinations generally don't work. The most effective cross-examinations, you watch Ally McBeal or Law and Order or The Practice. They do cross-examinations that are very, very effective without being overly aggressive. The Biscuit can do it with a very kind smile and in a very gentle fashion, and you'll watch George Hunter, who, notwithstanding that he appears kind and gentle, is a vicious human being, but nevertheless can appear very kind and gentle and do a very, very effective cross-examination. And I don't recommend this kind of aggressive style unless it really fits within your personality and you're very comfortable with it, because I think you do tend to upset the judge, and it's not worth it. But I do defend my attack on Mr. Rudson about the file, because the retainer letter is very important to me. I want to see what Mr. Niman told Mr. Rudson to do. Now, with Mr. Niman, it won't work because Mr. Niman's an old hand and he'll be very careful at his retaining letter. But an inexperienced lawyer will set out in a retaining letter all sorts of things that suggest a bias, a prejudice, or make trouble for the expert. So I want to see that letter, and definitely I want to see the notes of conversations made between Mr. Rudson and the various witnesses.
Yeah,
so
but
when somebody leaves
you'd never wait until trial, cross-examination, to ask for them, for God's
Well,
sake. You would have subpoenaed the file of the trial.
Well, sometimes I like to get the file and look at it during the break, because the examiner did not expect me to ask for the file, and sometimes there's gold, and if I get it in advance, they're prepared for it. And if I can keep an eye on the clock and I can take my cross-examination to 1 o'clock or to 11:30, I can get a look at this file and I can get somewhere. So I don't always, I have to think about it, but I don't always do it in advance. And I think people do leave files behind on purpose. I'm a Freudian in that regard. So if he left his file at the office, he had something to hide as far as I'm concerned, and I damn well want to see it. So I want at the break for him to go get his file and not have a chance to review it carefully and see what comes of it. In the last trial I did, which is, I guess, it's more than 2 years ago, there's an appraisal difference between two appraisers on a piece of property of $1 million. And that's a big swing on this piece of property. And we beat the appraiser because of what turned up in the appraiser's file, which was asked for in the middle of cross-examination. There was a devastating note in that file, and he couldn't explain it. And if I'd asked for it a month before, either the note wouldn't have been there, or he wouldn't have been able to explain it. And so
Well, in the event you ever get another trial, I would suggest that if you at least compromise to this extent by sending a letter the day before trial to the solicitor saying, you will, of course, have your witness bring his file with him to trial.
Oh, I will. I will generally do that.
Because if you didn't, I wouldn't give you the adjournment to go and get it.
Yes, Justice Jennings, I agree completely with that. I will probably somewhere in a letter try to bury a sentence that says, make sure your witness brings the file with you. But I mean, the rules are such today, the trial is based on full and complete disclosure. So, I mean, you used to have trials because it was the only time left in the world you could ambush somebody, and that's the reason we went into this business in the first place. If you're going to take all the fun out of trials, you may as well just go with Gertie and stay there for 4 days until you're settled. So once in a while, I want to see what is in somebody's file, and that's how I do it. And if they don't bring it, I try to get them to bring it.
It's interesting that Phil says that he's only had 2 trials, but if you ask him how many trials that he started, it's probably about 20 or so. And Phil has a very, I think, unique perspective. He always wants to act for the defendant. And the reason for that, Phil, is apparently that Phil believes he can win his case in cross-examination and never have to put his own client in the witness box. And I think that talent was demonstrated today. Style, I agree with what Phil said about style, but style also will vary with the witness, and sometimes you have to change your style considerably depending upon the demeanor of the witness. Wayne, do you have anything else you want to add?
Just one thing, and that is that Phil with his help, found the weaknesses in the report. And if you have a trial and you have your own experts, I think it's very worthwhile, and I don't get asked this very often, but ask your own expert, where are the weaknesses in your report? Where do you expect cross-examination to come? Because that way maybe you can deal with any damage in advance, deal with it in examination in chief, and sort of take the wind out of their sails, so to speak. So there's always going to be some areas of weakness, and I think if you can identify them in advance, you can deal with them a lot better than waiting to hear about it in cross-examination.
Justice Jennings, last word?
No, that's a good point.
Okay, thank you, Phil. Thank you, Wayne.
Thank you.
We're ready to roll the next video, which will be of Jerry Sadvari examining Audrey Joseph. Thanks, Phil.
Thank you. Nice going, see you. Yes, Mr. Sadvari.
Thank you, Your Honor. By the end of the evidence, Your Honor, some of Ms. Joseph's evidence may no longer be controversial, but I still hope that it will be of some assistance to the court. Ms. Joseph, you were involved as a mediator in an open mediation with Mr. and Mrs. Doe.
That's correct.
And during the course of that open mediation, you met all three of their children.
That's correct.
Now, I'm going to ask you to apply your expertise and give us your opinion on the effects of certain activities that it's suggested the children engage in. Let's deal with them one at a time. Firstly, Amanda, who's going away to school in September. And her father has made a suggestion that she work in the summer and that at some point in her undergraduate career, she also take on a part-time job. In your opinion, having met Amanda, do you think that is a good idea?
To work during the summer, yes. With respect to taking on a part-time job during the year, I don't think that would be in her best interest for the first year of university.
And specifically, why not?
I think that Amanda has a lot that's on her plate right now. She's still dealing with the stresses of the divorce and the divorce proceedings. She's finding it very difficult. I think in addition to the stress of the divorce, she's also got some anxiety about leaving home. It's going to be her first time living away from home. And in addition to leaving the home...
Ma'am, I want to get down most of what you said.
Oh, sorry.
Thank you.
In addition to leaving the home and the anxiety that coupled with that, also taking on a fairly challenging curriculum at the university level.
Now, that's first year and part-time work. What about subsequent years?
I think that it would be difficult to say because I think you would have to base on how she handles the first year. I think it's an individual decision. Some people do really well and some people don't do well with it. Certainly with the stresses that she's under, it may be more difficult for her to focus and concentrate on her studies. So to have an added responsibility, that being a part-time job, may make it more difficult and interfere with her being able to do well and achieve.
In your view, having participated in the mediation, how was she reacting to her parents' separation?
She's still upset about it. She still is quite confused and is worried about what's going to happen in terms of her mother and whether the family will be able to afford certain things.
Now, hopefully we don't have to come back to court every year on these issues, so I'll ask you a hypothetical question with respect to Amanda. If at some point in her undergraduate career she had the opportunity to take the summer and instead of working, study abroad in a course that related to her chosen field, whatever it might turn out to be. In your view, would that be a good thing for her to do?
Oh, it certainly wouldn't hurt. Studying abroad would be a very enriching experience for any child, I believe, in terms of living in another culture and learning about another culture. So no, it certainly wouldn't hurt her in any way.
Let's turn to Jason and his hockey activities. Now, for the purposes of your answers, please assume that it has been determined by the court that the expenses can be afforded by this family. What do you have to say about the benefits, if any, for Jason with respect to the summer program and as well the one-on-one lessons?
Well, certainly for Jason to continue to play hockey, I think would definitely be in his best interest.
For him to continue to play hockey?
For him to continue, yeah, would definitely be in his best interest. It's something that enhances his self-esteem. It builds confidence, and I think that both those things, self-confidence and high self-esteem, are critical at any stage of development, and particularly in the case of an adolescence.
Now, he had these private lessons last year. Mm-hmm. Would it have any impact on him if they stopped?
Well, if those lessons helped him to feel better about himself and better about his abilities in playing hockey, and he were not to have those lessons, and he started to feel somewhat, just started not to feel so good about himself and started to maybe question his abilities, started to feel more insecure about his abilities, then that would certainly have an effect, yes.
Does it matter?
Just a second, Mr. Sadvari. You said if the effect of stopping hockey was to make him feel less confident or less secure, that
And
would be a
create
bad
insecurities,
thing.
that would not be in his best interest. If he started to feel...
Well, I can accept that, but you said if. I mean, can you tell me as to whether, in fact, he would lose his sense of self-esteem if he stopped playing hockey?
If he stopped playing hockey altogether? Yeah, I think he would, if he wasn't able to play hockey anymore, I think he would start to feel discouraged. But I think more important than losing his self-esteem, he would feel that his parents weren't supporting something that was very important to him. And I think that's as an important issue as his self-esteem, but for him to also feel that his parents are supporting something that is important to him.
And
Sorry, Mr. Sadvari, go ahead.
thank you, Your Honor. Given that he had the private lessons last year, would their cessation this year have the effect that you just described?
That he would feel that his parents aren't supporting his goals?
Yes, ma'am.
I think it's possible.
We've seen in evidence a scouting report, which is not of the most laudatory nature with respect to Jason. Does it matter whether these activities lead to an NHL career or not as far as his best interests are concerned?
I think that whether Jason is an exceptional hockey player is not an issue that I would see as relevant in the consideration of his best interests.
Thank you. Now, lastly, Samantha is taking ballet lessons, and once again, with all due modesty, there doesn't appear to be any extraordinary ability shown yet, but in the course of your discussions with the family and Samantha, what benefit, if any, have these lessons provided her?
Again, very similar to the benefits that Jason has been provided by having the opportunity to take hockey. She feels very good about herself. She enjoys the activity. It gives her satisfaction and a lot of pleasure.
And did you discuss with her the expansion of the scope of her lessons? Is she talking about taking more?
Yes, she is.
And once again, the expense aside, is that something that, in your opinion, would be good for her to do?
Yes, I think it would. Also, I think it's important for the parents to support that for the reason that they not be seen that they're discriminating between the children. If Jason is having the hockey program, then Samantha should certainly be allowed to pursue an activity of her interest.
Thank you, Ms. Joseph. Those are my questions of this witness, Your Honor.
Thank you, Mr. Barrett. Ma'am, you said that Jason's hockey playing ability, as far as you're concerned, wasn't really relevant to determining what was in his best interest.
Right, whether he's an exceptional player or not, I would, even if he was playing at the house league level, I would still support that he be allowed to continue playing hockey.
I take it then you see no danger in a child who is never able to achieve his goals in a particular sport, focusing his life on it to the exclusion of other activities in a failing attempt to get to a certain stage which was beyond his grasp.
Do I feel the parents should support him even if it's to fail, like to failure.
Well, is there any adverse effect on the child?
No, I don't think so. I think it's more important for the child to feel his parents' support, even whether it's to failure or to success in whatever he does.
All right, thank you. Thank you, Mr. Sadvari.
Thank you, Your Honor.
Could I ask Jerry and Audrey just to come up for a second? We'll move along quickly here. Comes over here. I want to ask Jerry, first of all, how would you qualify this witness? How would you get this evidence before the court in the first place?
Apparently with great difficulty. It's a good thing there was no cross-examination except for His Honors. The qualifications as a social worker, hopefully, would allow her to make comment on some of the evidence I tried to get in. Frankly, the way the evidence ended up going in from the husband, it varied considerably from the case that I was preparing for based upon the pleadings, and probably I would have ended up not calling Audrey in this particular case because the husband ended up being so reasonable and supportive. But I think the idea here was to try and look at old familiar issues in a new way, and perhaps with a little lateral thinking in the right case, finding some assistance to the court from someone who is outside the family and more familiar with child-related issues.
Audrey, have you been called on to give evidence like this, excuse me, in real life? Has anybody approached you with this, and do you see there being any particular benefit in your doing this in your capacity as an assessor and therapist, I guess?
In answer to your first question, yes, I have been called on numerous occasions to give evidence, whether it be on an assessment or open mediation that I've done. And in answer to your second question, yes, I think it is extremely helpful.
I think it's on this issue, that is, on the child support issue.
Well, on the child support issue, we were talking about how this evidence might get in, and we decided that the only, really the most likely possibility is the Section 7 issue, that the court is directed to look at the best interests of the children, and that's sort of the way we get it. Justice Jennings, I don't think you like this evidence very much.
Well, the facts were stacked against Ms. Joseph in this case. I think you're right. I guess what was happening was the direction in Section 7.1 that taking into account the necessity of the expense in relation to the child's best interests, the court made, da-da-da-da-da. And so they were going to lead an expert to tell me what was in the child's best interest. Okay. On the facts of this case, I would have had some problem with the qualifications of not the qualifications, with the relevance of the evidence and the necessity of the evidence that was to be offered if it had been seriously challenged. I've already got time to go into it, but there is a growing trend for courts to clamp down a bit on expert opinion evidence on everything, and I'll give you 3 sites that you may want to put into your armory. It begins with Justice Sapinka, the late Justice Sapinka in Mohan, Queen against Mohan, 1994, 2 Supreme Court Reports 9. He sets out the four threshold tests. The proposed relevant evidence has to be that of a properly qualified expert. Secondly, it has to be relevant. Thirdly, it has to be necessary in assisting the trier of fact. And of course, fourthly, it has to can't be the subject of any exclusionary rule. And 2 recent cases of our Court of Appeal have modified to some extent, or perhaps expanded is a better word, Mohan, are against McIntosh, 1997, 35, Ontario Reports 3rd at 97, where the court held that a properly qualified expert includes the concept that the expert is testifying about a recognized body of scientific knowledge. And there was a special caveat to be wary of the evidence of psychologists. And the last case, which is out in a recent pamphlet copy of the ORs, is R against BM, 1998, 42 OR 3rd at page 1, where the Court of Appeal reviewed the decisions and the law on the matter. It includes, with approval, obviously, this quote from Mohan, which I leave with you. Dealing with the question of the necessity of the court having the expert evidence, the quote is, "What is required is that the opinion be necessary in the sense that it provide information which is likely to be outside the experience and knowledge of a judge or jury. The evidence must be necessary to enable the trier of fact to appreciate the matters in issue due to their technical nature. In order for expert evidence to be admissible, the subject matter of the inquiry must be such that ordinary people are unlikely to form a correct judgment about it if unassisted by persons with special knowledge." Well, what the mythical social worker was going to do here was to say that hockey is nice, and kids would rather play it than not. And this kid has played hockey before, and it would be nice if he could keep playing hockey, and it might be unnice if he couldn't.
It was too
On the
self-evident?
threshold, I could see if
Too
the
self-evident
child-
for you?
If the child had been in therapy for 4 or 5 years, and the therapist was called to say, "I've got a really difficult patient on my hands, and if you interfere with this particular activity, I can forecast cataclysmic psychiatric consequences," I guess I'd be persuaded much more easily than I would have been in this case.
Justice Jennings, one of the things that Audrey and I discussed as a potential case where her role might be of more assistance to the court is the split household, a second family, where there's a large discrepancy between the two households' lifestyle, and the children go back and forth, and they see this enormous contrast. Is that something, the effect on the children of going back and forth and seeing that, is that something that might be too self-evident as well, or might there be some assistance?
Is that a specialized body of knowledge about which there's a growth of expert opinion? I'm not sure. I'd really want to hear argument. The message I'm trying to leave with you is when you're served with an expert's report and you're told it's coming into trial, don't give up. I mean, go read the authorities and see whether this is something that can be attacked. And I think in the area that Jerry just outlined for you, there's a lot of grayness and
On balance,
see some vulnerability.
On balance, Justice Jennings, if we had had the other side there attacking the introduction of the report altogether, do you keep that report out?
What was that?
The question is, do you allow the report in the first place, or do you say that there isn't the qualification foundation made out?
Would I allow this report?
Exactly.
On what I learned, I would have found that I didn't need that help on this particular case coming from someone who'd seen the child once in mediation.
All right.
I mean, I know kids like hockey. I know kids like McDonald's. I don't know that I need an expert to tell me that.
Any response, Jerry, Audrey?
No.
We withdraw the evidence.
Thank you. We'll move on. Thank you very much.